Relations between Union and States. A Constitution of India provides a dual polity with a clear division of powers between the Union and the states, each being supreme within the sphere allotted to it. The states in India are not the creation of the centre, nor do they draw their authority from the Union government. Constitution of India has made most elaborate provisions regarding relationship between the Union and the states. This was done with a view to minimize the conflicts between the centre and the states. Legislative relations. The Union-State relations in the legislative sphere have been dealt by Articles 245 to 254. The Constitution clearly provides that the Parliament shall have exclusive jurisdiction to make law for the whole or any part of the territory of India with regards to subjects mentioned in the Union list. This list contains 97 subjects like defense, foreign affairs, currency, union duties, communication, etc. On the other hand, the state enjoys exclusive power over the 66 items enumerated in the state list. The list contains subjects like public order, health, sanitation, agriculture, etc. In addition, there is a concurrent list containing 47 subjects like criminal law and procedure, marriage, contracts, trust, social insurance, etc., over which both the union and the state governments can legislate. The Constitution also vests the residuary powers with the central government. It may be noted that in this distribution of powers, the Union government has certainly been given a favoured treatment. It has not only been granted more extensive powers than the states, even the residuary powers have been granted to it contrary to the convention in other federations of the world, where the residuary powers are given to the states. Union power of legislate on states subject. If the Rajya Sabha declares by resolution supported by not less than 2/3 of the members present in voting that it is necessary or expedient in the national interest that the Parliament should make laws with respect to any matter enumerated in the state list specified in the resolution, such a resolution remains in force for a period of 1 year and can be further extended by 1 year by means of a subsequent resolution. The Parliament can legislate on the subjects mentioned in the state list when the proclamation of emergency has been made by the President on grounds of internal disturbances or external aggression. However, the laws thus made by the Parliament shall cease to have effect on the expiration of the period of 6 months after the proclamation has ceased to operate, except as respects things done or omitted to be done before the expiry of the said period. Thus, during emergency, the Parliament can legislate on subjects in all the 3 lists and Federal Constitution gets converted into unitary one. The President can also authorize the Parliament to exercise the powers of the state legislature during the proclamation of emergency due to breakdown of constitutional machinery in the state, but all such laws passed by the Parliament cease to operate 6 months after the proclamation of emergency comes to an end. The Parliament can also be authorized to legislate on the state subject if the legislatures of 2 or more states feels it desirable that any of the matters with respect to which the Parliament has no power to make laws for the states should be regulated in such states by Parliament by law, and if resolutions to that effect are passed by legislatures of those states, thereafter any act passed by the Parliament shall apply to such states and to other states by which it is adopted afterwards by resolution passed in that behalf by the House, or where there are 2 houses by each house of legislatures of that state. The Parliament also reserves the right to amend or repeal any such act. The Parliament can make law for the whole or any part of the territory of India for implementing any treaty, agreement or convention with any other country or countries, or any decision made at the international conference, association or other body. Any law passed by the Parliament for this purpose cannot be invalidated on the ground that it relates to the subject mentioned in the state list. Certain bills passed by the state legislature have to be reserved by the governor of the state for the consideration of the president. These bills become law only after the president gives his assent. The bills which the governor must reserve for the consideration of the president relate to compulsory acquisition of the property, or those which adversely affected the powers of the High Court. Administrative relations. The administrative jurisdiction of the Union and the state governments extends to the subject in the Union list and state list respectively, which clearly establishes the superiority of the Union government in the administrative sphere as well. In addition, the Constitution contains a number of provisions which accord to position of superiority to the Union government. Article 256 lays down that the executive power of every state shall be so exercised as to ensure compliance with the laws made by Parliament and any existing laws which apply in that state, and the executive power of the Union shall extend to the giving of such directions to a state as per appear to the Government of India to be necessary for that purpose. Similarly, Article 257 of the Constitution provides that the executive power of every small state shall be so exercised as not to impede or prejudice the exercise of the executive power of the Union, and the executive power of the Union shall extend to giving of such directions to a state as may appear to the Government of India to be necessary for that purpose. In short, the Union government can issue directions to the state government even with regards to the subject enumerated in the state list. Union's power to give directions. The Union government can also give directions to the state with regards to construction and maintenance of the means of communication declared to be of national or military importance. It can also ask the state governments to construct and maintain means of communication as part of its functional with respect to naval, military and air force works. It can also issue them necessary directions regarding the measures to be taken for the protection of the railways within the jurisdiction of the state. It may be noted that the expenses incurred by the state governments for the discharge of these functions have to be reimbursed by the Union government. It may be noted that the state governments cannot ignore the directions of the Union government. Otherwise, the President can take the plea that the government of the state cannot be carried on the accordance with the provisions of the Constitution and impose President's rule on the state. In such an eventuality, the President shall assume to himself all or any of the functions of the state government. The President of India can also entrust to the officers of the state certain functions of the Union government. However, before doing so, the President has to take the consent of the state government. Further, the extra cost incurred by the state in the discharge of these obligations has to be reimbursed by the Union government. All India services. The presence of the All India services like the Indian Administrative Services and the Indian Police Services, etc., further accords a predominant position to the Union government. The members of these services are recruited and appointed held by the Union Public Service Commission. The members of these services are posted on key posts in the states but remain loyal to the Union government. The right to create new All India services also rests with the Union Parliament. The Union Parliament can create a new All India service only if the Rajya Sabha passes a resolution by 2/3 majority of the members present in voting that it is necessary in the national interest to do so. Water disputes. The Parliament has been vested with the power to adjudicate any dispute or complaint with respect to the use, distribution or control of the waters of or in any interstate river or river valley. In this regard, the Parliament also reserves the right to exclude such disputes from the jurisdiction of the Supreme Court or other courts. Responsibility of the Union. Under the Constitution, it is the responsibility of the Union to protect the states from external aggression and internal disturbances. This leaves a much scope for centre's interference in the spheres of the state. The President can declare national emergency in case of war or possible threat of war as well as armed rebellion. During this emergency, the centre can give direction to the states as to the manner in which their executive power is to be exercised. The President can authorize the Parliament to make laws with respect to any matter including power to make laws, conferring powers and imposing duties, or authorizing the conferring of power and the imposition of duties upon the Union officers and authorities of the Union as respect that matter, and mindful of the fact that the matter does not belong to the Union list. Role of governors. The central government exercises effective administrative control over states through the governors of the state who are appointed by the President and hold office during his pleasure. The governors can reserve certain bills passed by the state legislatures for the consideration of the President. President can also issue directions and orders to the governor which are binding on him. Thus, the centre can exercise effective control over the states through the government to topple state governments which are irksome to the central government. Judicial system. As the Constitution of India provides for a single judicial system, both the Union and the state governments are duty-bound to give full faith and credit to public acts, records, proceedings and judicial decisions of the Supreme Court and the High Court. The manner in which these acts, records and proceedings have to be preserved is determined by Parliament by law, and the states do not have any say in this regard. In the matter of appointment of the Chief Justice and the judges of the Supreme Court as well as the High Courts, the states have no say. They are appointed by the President in consultation with the Chief Justice of India and such other judges of the Supreme Courts and the High Court as he deems fit to consult. The initiative for the removal of these judges also rests with the Parliament, which can pass a necessary resolution for their impeachment and recommend to the President to take necessary action. The states are in no way connected with the appointment or removal of the judges of the Supreme Court or High Court. State government's power. The state governor can entrust conditionally or unconditionally certain functions with respect to the executive powers of the state to the officers of the Union with the consent of the Union government. Article 258A. It may be observed that the original Constitution did not contain this provision. This provision was added through 7th Amendment in 1956 in view of the objections of the Comptroller and Auditor General over construction of Hirakud Dam by the central government on behalf of Orissa government in debating. Of cost. Impact of the 42nd Amendment Act. A new turn was given to the centre-state relations in the administrative sphere by the 42nd Amendment of 1976, which empowered the central government to deploy armed forces for dealing with any grave situation of law and order in the states. The contingents so employed were to act in accordance with the instructions of central government and not to work under direction, superintendence and control of the state government concerned unless specifically directed by the central government. This change naturally greatly restricted the autonomy of the states and was resented by the states. Ultimately, this provision was nullified by the 44th Amendment. It is thus evident that in the administrative sphere of the states cannot act in complete isolation and have to work under the directions and in cooperation with others of the Federation. Financial relations. Taxes exclusively assigned to the Union. Income from certain subjects like customs and export duties, income tax, excise duty on tobacco, jute, cotton, etc., corporation tax, taxes on capital value of assets and individual and companies, estate duty and succession duty in respect of property and other than agricultural land, and income from the earning departments like the railways and postal departments have been exclusively assigned to the Union government by the Constitution. Taxes exclusively assigned to states. Income from land revenue, stamp duty except on documents included in the Union list, succession duty and estate duty in respect of the agricultural land, income tax on agricultural lands, taxes on goods and passengers carried by roads or inland water, taxes on vehicles used on roads, animals, boats, taxes on the consumption or sale of electricity, tolls, taxes on lands and buildings, taxes on professions, traders, calling and employment, duties on alcoholic liquors for human consumption, opium, Indian hemp, and other narcotic drugs, taxes on the entry of goods into local areas, taxes on luxuries, entertainments, amusements, betting and gambling, etc., has been assigned to the states. Taxes leviable by Union but collected and appropriated by the state. The taxes on the following items are levied by the Union government, but the actual revenue from them is collected and appropriated by the states. Stamp duties on bills of exchange, checks, promissory notes, bills of landing, letters of credit, policies of insurance, transfer of shares, etc. Excise duties on medicinal toilet preparation containing alcohol or opium, on Indian hemp or other narcotic. Taxes levied and collected by the Union but assigned to states. The taxes in this category are levied and collected by the Union government, although they are subsequently handed over to the states where from they have been collected. Such taxes included duties in respect of succession to property other than agricultural land, state duty in respect of property other than agricultural land, terminal taxes on goods or passengers carried by railways, sea or air, taxes on railway freights and fares, taxes other than stamp duties on transactions in stock exchanges and future markets, taxes on the sale or purchase of newspapers and on advertisements published therein, taxes on purchase or sale of goods other than newspapers, where such sale or purchases take place in the course of interstate trade or commerce. Taxes levied and collected by the Union but shared with the states. Taxes on income other than agricultural income and excise duties other than those on medicinal and toilet preparations are levied and collected by the Union government but shared with the states on an equitable basis. The basis of distribution is determined by the Parliament through law.